Sir, there are a few queries which I would
Yes,
like to post and so that you can clarify.
yes.
Mr. Mobur Prasad has asked, when IPR is obtained in one nation,
Hmm.
again certification is needed with other nation. Why?
That is basically because of the variation in the domestic laws of the countries. We do have certain treaties which speak of a single application for protection on the territories of all other countries. For example, you have the Patent Cooperation Treaty, PCT, which was signed for the purpose of making it easy for the inventors to protect the inventions on the territories of all the countries. Under the PCT, one single application is sufficient to acquire protection on the territories of several countries. Now, if a person has to file an application on the territory of each country, then he has to pay the fee there. And countries like US and Canada, Australia, the fees are very high, and a small inventor cannot afford that much of fees. And in fact, I had suggested in one of my articles that I wrote that is need for a universal global patent. That is, one patent that is granted by an international authority must be valid on the territories of all the other countries, so that it will help small inventors also to protect the inventions on the territories of the powerful and developed countries. But in most of the in respect of most of the intellectual properties like copyright and then of course, in the case of trademarks, we have this Madrid Convention on the International Registration of Trademarks. But in all other categories of intellectual properties, the owners of the intellectual property have to go through the process of filing an application on the territories of other countries. And the application of the uh, intellectual property right holder must be customized in accordance with the terms and conditions that are laid down by the domestic laws of each country. So this problem does exist. But in the case of patents and trademarks, somewhat the procedure of acquiring protection on the territories of other countries has been simplified. But in the case of all other countries, it still remains the same.
Hope the idea suggested by you will be taken up by the international by the governments. Another question, sir: why a trade name, as in Article 8 and 9, is protected without obligation of registration? This is Article 8 and 9 of the Paris Convention, I suppose, sir. Why not IPR is also protected without registration like trade name?
What we must understand is, in the case of all intellectual properties, for instance, in a patent is a patent, a copyright is a copyright, a trade secret is a trade secret, geographical indication is a geographical indication. But in the case of trademarks, there are two aspects to a trademark. One is a trademark and a trade name. So, when a trademark is protected on the territory of a country, the trade name that is associated with the trademark will get automatic protection. That is what it means. And I gave you examples of a trademark and trade name, companies having both. So when the trademark is protected on the territory of a country, obviously, automatically, the trade name that is associated with the trademark must also be automatically protected on the territory of that country. That is what is the principle of automatic protection. Clear?
Yes, sir. Hope it has been clarified, sir. Thank you. Sir, next question, sir, by one Mr. Chandrasekhar Patnaik. Sir, if any dispute is not settled even in International Court of Justice, then what is the solution?
Uh, by the time the international regime of intellectual property came into existence, International Court of Justice has in fact is a court that deals with disputes between states. Because the statute of the International Court of Justice is very clear. It says that only states can be parties to a dispute before the court. And disputes in respect of intellectual properties can be between individuals. So the court shall not entertain cases of individuals, the International Court of Justice. That is precisely the reason why the WTO agreement has been signed, the World Trade Organization, and disputes relating to the agreements, provisions, and then also intellectual property disputes between countries, individuals, can be referred to the World Trade Council. And in fact, a mechanism has been established under the World Trade Organization, which is known as the dispute settlement mechanism. And this dispute settlement mechanism is actually handled by a body known as the dispute settlement body, which takes up all disputes relating to trade as well as disputes relating to intellectual property rights. So today we have this mechanism in place for disputes being settled. Okay.
So then the role of ICJ does not come into picture here, sir?
Absolutely no.
Okay, sir. Thank you,
ICJ
sir.
has no role to play.
Okay, sir. Thank you for the clarification, sir.
Yes.
Next question, sir, by one Mr. Ritvik. Respected sir, could you please enlighten me on the term utility model? Basically, the meaning of the term.
As I said, utility models are still in vogue in a few European countries. It is a kind of a smaller patent. It is nothing different from a patent. Now, all other countries use the word patent while protecting an invention. And in the case of those countries which provide utility models, a utility model is nothing but a smaller patent that is granted in respect of an invention. The size of the invention is something that is debatable, because only those countries can tell us what invention is small and what invention is big, and under what, in respect of what inventions a utility model is granted, and in respect of what inventions a patent is granted. Only those countries can tell us. So as I explained during my address, that utility models are kind of smaller patents. They are also given in respect of inventions only, but they are known as utility models.
Sir, next question, sir, by one Mr. Rajaswamy Aldandi. Sir, whether any malware or virus software can be registered under IPR? What are the principles that should be followed to register in IPR?
Malware per se cannot be registered, because any invention shall be protected under a patent if it is for the public good. And a malware is certainly not against public good. So the provisions do not specifically speak of malware. It lays down a broad provision saying that any invention which is against public good or against public morality or which is against public policy shall not be protected. So there is no specific provision. Even under the internet treaties also, they only say that no protection shall be granted to software that is against public good. So this term public good covers everything. That includes malware also.
Last question, sir, from Dr. H. Ram Mohan Rao. When domestic law on patent, trademark, copyright, etc. is in conflict with international convention, which law will prevail?
Obviously, the domestic law. Because when states sign an international treaty or convention, the convention lays down broad guidelines. As I stated earlier, no convention or treaty is country specific. If a treaty or convention is country specific, it's impossible because of so many countries being parties to the convention. So only broad guidelines are laid down by the treaty or convention, and the treaty or convention gives discretion to the member states to have their own provisions. The provisions can be of a higher protection to intellectual property. And in those countries where there is no legal expertise, there is no expertise in intellectual property knowledge, the protection may be less in respect of intellectual property. But in the event of a conflict between the provision of a domestic law and the provision of an international convention, the provision of the domestic law shall prevail.
I have one more query, if you permit me, I will ask, sir. Sir, any specific convention regarding neighboring rights?
Rome Convention deals
Okay.
with neighboring rights. I could not go into that because of the paucity of time. Neighboring rights is covered by the Rome Convention, and neighboring rights are rights of performers, rights of producers of phonograms, and rights of broadcasting organizations. All these three categories of uh, rights are protected under the Rome Convention. Because in the case of the right of a performer, earlier performers did not have rights. For example, all the film stars who act in films, then the people who act in dramas and then serials, they had no rights earlier. And in fact, there were a lot of disputes. One example is that of the late actor Devanand. In one movie, he had acted, and the producer promised a certain amount of money, and the producer did not pay the money. And Devanand approached a court of law to stop the release of the film because the producer had not paid the amount promised to the actor. But the court said there is no law to prevent the producer from releasing the film because there was no right for a performer to exercise. So, keeping in mind these kind of disputes in other countries also, the rights of performers were introduced, and similarly, rights of producers of phonograms and then rights of broadcasting organizations. All these three together constitute neighboring rights which are attached to copyright, and they are all dealt with under the Rome Convention.
Sir, a small follow-up question, sir, from Chandrasekhar Patnaik. Sir, with respect to the WTO Dispute Settlement Board, can a state seek legal assistance even if it is not a member of the WTO?
It is necessary that the state must be a member of the WTO.
Okay, sir. Thank you so much, sir. Now I request Professor GB Reddy, sir, IPR Chair Professor, to kindly share his views.
Thank you, Dwarakanath sir, for an excellent presentation. Uh, I just have one or two comments to make, only to sum up. One is about the utility model, sir. As you know, you have already explained very well. It is for a lesser inventive step, because if the degree of inventive step is lesser, then short-term or economic patents are granted in the form of utility models, as sir rightly pointed out. If the novelty, utility, and non-obviousness in the strict sense are complied with, they may go for patent. But if the knowledge is already there, but if it is an improvement over and above the existing knowledge, like we are giving patent of addition in India, in some countries, in fact, separate patents are granted like utility models. They call it second tier protection. The 2016 IPR policy also refers to that, but it has not considered it seriously. Second point, sir, mentioned very clearly about the patents, especially with regard to the public good. But suppose somebody is claiming copyright and all. After this WCT and WPPT provisions are incorporated in the form of 2012 amendment in the copyright law, there are provisions relating to technology protection measures and anti-circumvention measures. Therefore, under the copyright law also they cannot be registered, virus or malware. That is the second one, sir. These are the only two interventions with the permission of my senior professor, Professor Dwarakanath, sir. Sir, I take this opportunity to thank you on my personal behalf because today is the first day of the new year, and in spite of having so many programs, you spared your invaluable time for almost 1.5 hours, or maybe more than 1.5 hours with the participants. And I also thank the participants for sparing their valuable time. Almost about 100 participants have remained on online in online mode, and I'm very sure that the purpose of organizing this lecture by the eminent international law professor is